Welcome, everyone, and thank you for joining us today. My name is Floriane Laveau, and I'm a counsel at Debevoise and Plimpton in New York. I am delighted to be with you all today, virtually for now, and hopefully in person next year. Before we get started, I would like to take a moment to set the stage and introduce our fantastic speakers. The topic we will be discussing today is how international law should respond to the multiple and profound challenges that climate change has created. The reality is that sea level rise is at the core of many of those challenges. As we will discuss, changes to the geographic reality of the world's coastlines will present a host of issues for the law of the sea, but they also raise other issues like statehood of submerged island states and state responsibility for climate change. So how should international law respond to those challenges? Today, we will be focusing, although not exclusively, on the fate and legal status of persons displaced as a result of climate change and sea level rise. This is a timely, even urgent topic. Urgent, of course, for the many people whose lives and livelihoods are affected by climate change. And also because much is happening these days on the international law plane to confront and address this phenomenon. For example, the Human Rights Council recently recognized for the first time that having a clean, healthy, and sustainable environment is a human right. And of course, the world has its eyes on Glasgow, where COP26, the UN Climate Change Conference, is starting on Sunday. So to grapple with those issues, we have a fantastic lineup of speakers, all of whom are truly at the vanguard of the most important international law and policy-making bodies related to the law of the sea and climate change. Starting with Elisa Fornale, who is a Swiss National Science Foundation professor at the World Trade Institute at the University of Bern. She specializes on international law, climate change, human mobility, and human rights. Earlier this year, and congratulations to her, Elisa was appointed as co-rapporteur of the ILA Committee on Sea Level Rise and International Law, and she's also a member of the advisory committee of the Platform on Disaster Displacement. Now turning to Cecilia Jimenez de Mari, who has served since 2016 as the special rapporteur on the human rights of internally displaced persons. Cecilia has over 3 decades of experience in NGO human rights advocacy for the Asia-Pacific region. She recently authored a report that was presented to the General Assembly on human rights and internally displaced persons, as well as another report presented just this year to the Human Rights Council on housing, lending, and property issues in the context of internal displacement. Turning to Donald Rothwell, who is a professor of international law at the ANU College of Law of the Australian National University. He's co-editor of the Australian Yearbook of International Law and editor-in-chief of the Braille Research Perspectives in Law of the Sea. He previously served as rapporteur of the ILA Committee on baselines under the international law of the sea, and he's the author of countless books and articles. And his next major work, Islands and International Law, will be published next year, so stay tuned. And last but not least, Nicola Swan, who is a partner in the litigation and dispute resolution team at Chapman Tripp in New Zealand, where she leads the firm's international law practice. And I am very proud to say, my friend and former colleague at Debevoise. Nicola is a member of the IBA's Environmental, Social, and Governance Arbitration Committee, and she previously served as secretary to the IBA Presidential Task Force on Climate Change Justice and Human Rights. Welcome to you all. It is great to have you. Before we start, I just want to say that we would love to reserve some time for questions from the audience. So feel free to suggest questions in the chat functions, and I will do my best to pick them up at the end. So now let's begin. And I'd like to start really by framing the issues. And in order to do that, I think it's really important to first understand the facts and the extent of the problem. So what is the impact of climate change and sea level rise on coastal states? How many people are affected? Where in the world in particular? What are the current scientific predictions? And on that, I would like to turn to you, Elisa.
Okay, thank you a lot. Thank you, everybody. So good evening from my side, but I think maybe it will be good afternoon, good morning somewhere else. So thank you a lot, Florian, for first of all for bringing us together today, because I think it's a very timing opportunity for us to discuss all together the role of international law, in particular in the context of climate change and sea level rise. For me, it's a really great pleasure to join and to introduce this section. As you say, I will do my best to provide you some data concerning the impact of a slow onset event on human mobility, and also I will try to provide you a very brief introduction to the science of sea level rise. And for this, I acknowledge also the support I received from the Ocean Center on Climate Change, so from Professor Froliker, who support me in identify also the data. So what we know now is that the scientific evidence now really leaves little doubt that the exposure to the slow onset event is leading to very negative effects on the affected population and is resulting in forced mobility both within countries and also across borders. So in particular, we are seeing that inhabitants of small island states and coastal areas will face substantial impacts. So for me, it's also important to remind that around 680 million people lives in low-lying coastal zone. So this was nearly 10% of the 2010 population globally. So as you can see, I share with you this slide just to give you an overview of the number of internally displaced persons. And as you can see, this number fluctuated between 15 to nearly 35 million in around 12 years, and newly displacement were mainly really linked also to natural disaster, not more on conflict as it was maybe a few years ago. And in 2020, the most affected area was in particular Asia. And I would like just to raise the fact that the Internal Displacement Monitoring Center reported, for instance, that also the Pacific region was particularly affected. And in 2020, the number of people, for instance, internally displaced by disaster in Vanuatu was around 80,000, and in Fiji it was 37. But if we try also to look at the bigger picture, I will say, we can identify that over 80 million people were forcibly displaced in 2020. So, and what also is important to notice is that the big majority that concerning the data that we have available are displaced internally, because it's much more complex to identify and to get data about cross-border mobility. This is also, I think, something that it's important to remind. If we look also at projection for the future, and I think it's also important to share this data, because if what the recent groundswell report that has been just released and put in really in evidence is the fact that if we are unable to identify or to put in place really concrete action in the field of climate change, the previous number that I identify could increase 4 times. So we can reach 260 million of internally displaced persons. And again, we see as the most affected region, Asia, together with Africa. For instance, sea level rise in Bangladesh could submerge 70% of the country and affect 20 million people who will risk losing their homes. So I think just very briefly, these realities illustrate how the present, but also the future impact of changes in sea level rise could interfere with the full enjoyment of human rights. And this is quite important for the topic of our debate today, because this could really concretely create unprecedented protection gaps. Now, as I said, I think it's also important to try to frame our debate today, to try to share also some data concerning the science of this specific issue. And what we know is that the global sea level rise increased by 20 centimeters since the beginning of the 90s, and it's confirmed that human-caused global warming was the main driver of this increase. So what are the predictions for sea level rise for the upcoming years? It's virtually certain that sea level rise will continue to rise. And the scientists are working with different scenarios. So as you can see, I identify, and this is also from the IPCC report, there are two possible scenarios. The blue one, if we are able, the international community, to put in place ambitious mitigation efforts, and the red one in the case that we will have not sufficient emission mitigation. And again, it's just another picture to give you some data about the possible impacts. And I conclude this very, very brief overview just to identify possible responses. And I'm sure that we are going to discuss more in detail during the presentation. It's really another an overview that the IPCC report tried to identify in 2019. It was a specific report on the ocean and the cryosphere. And if you see, there are different scenarios again, where we can each member state can decide, also has the possibility to adopt specific strategies in the short term. And if we look specifically to migration, and more generally, if we refer to human mobility, so if we include displacement and migration, this has been identified as part of the retreat strategies. So if there are not other possibilities that are adopted at the state level, in the long or mid-term, also migration could enter into the picture. So I'm sure that it was just a preliminary introduction to open the floor to our debate now. So I give the floor to the next speaker now. Thank you.
Thank you, Elisa, for sharing those insightful remarks. Let me turn to you, Donald. Before we delve into the issue of migration specifically, I'd like us to discuss the impact of those developments on the law of the sea. And you're one of the world's leading experts on this particular topic. So tell us, what are the legal implications of physical changes to coastlines as a result of sea level rise, from the standpoint of the law of the sea, Donald?
Well, good morning, everyone from Canberra, Australia. It's a great pleasure to join you, and thank you to my ILA colleagues for the invitation. So, recalling that all maritime entitlements are asserted from the baselines of a coastal state, whether that's a continental state with offshore islands, or an island state, the issue that arises is the impact sea level rise would have upon the features from which maritime entitlements are asserted. So the effects of sea level rise for coastal states and their maritime entitlements commence with the diminution of the land territory from which a maritime claim is asserted. This can range from minor impacts upon baselines to significant reduction in the size of the land territory, with flow-on implications for the coastline. So the most immediate effect of sea level rise will be upon baselines and the relevant UNCLOS rules with respect to normal baselines, straight baselines, mouths of rivers, bays, and low tide elevations. And they're all reflected in Articles 5, 6, 7, 9, 10, and 13 of the Law of the Sea Convention. Now, as we all know, the low water line is the most susceptible to sea level rise and is the basis for the Article 5 baseline rules. Now, Historically, this rule and this line has been recognised as being ambulatory, and as such has been subject to variations in the low water line, raising issues for how coastal states are to respond, given the expectation that the low water line be marked on official charts. Straight baselines and their variants rely upon natural features for the drawing of the baseline to and from the coast, a number of which will be susceptible to the impact of sea level rise. Smaller islands that are relied upon as baselines, as base points for Article 7, straight baselines may diminish in size, and the impact of this phenomena may be de minimis, but it may also be much greater if those islands completely disappear from a fringe, and as a result, straight baselines may no longer be possible to be drawn along that coastal vicinity. So the impact of sea level rise for maritime boundaries is not confined only to island states or archipelagic states, but also extends to continental states, given the number of states which in some way place reliance upon straight baselines or the maritime entitlements of islands or rocks for the purposes of determining their maritime boundaries. So there are three potential scenarios here. The first is where a juridical island or a juridical rock impacted by sea level rise is the basis for a settled maritime boundary. Secondly, where there are ongoing negotiations for the settlement of a maritime boundary in which sea level rise dynamics have become a consideration. And the third is where maritime boundaries have yet to be negotiated, but which will involve features that will be subject to sea level rise. So as with respect to the first scenario, there may again be de minimis implications which the affected states may determine to overlook. However, in my second and third scenarios, there will be other interests that will need to be taken into account. And this will especially arise in the case of overlapping exclusive economic zone and continental shelf maritime boundaries, where distant islands have been relied upon for the purposes of extending a maritime entitlement. If a juridical island, for example, becomes a juridical rock and is therefore no longer capable of generating an exclusive economic zone or a continental shelf, then the outer limit of a maritime zone may be radically impacted, such that there is now an area of high seas and deep seabed in an area of the ocean previously considered to be under state jurisdiction and resource sovereignty. Such a scenario would engage the interests of the international community, including, I suggest, the International Seabed Authority. So the potential unravelling of well-entrenched maritime boundaries due to this phenomena would have a significant impact on the certainty and stability of the maritime order and international law in general. So one response is reflected in state practice is to fix baselines from which maritime entitlements have been asserted and which in turn are the basis for the maritime boundaries. Likewise, there are state practice and support for fixed outer limits of maritime boundaries, which would not be disturbed as a result of sea level rise. The issue arising from these proposals is that they are to the benefit of a relatively small group of coastal states, but not necessarily for the benefit of the international community. States currently engaged in maritime boundary limitation and are sensitised to sea level rise are therefore at least able to buttress any agreement against the impact of sea level rise. Fixing the outer coordinates of a settled maritime boundary with precision will be, of course, of assistance. Finally, of course, there are some treaty law dimensions to what I've been mentioning, especially the Vienna Convention on the Law of Treaties and the application of Article 62, Fundamental Change of Circumstances Rule. The impact of sea level rise upon a settled maritime boundary may well constitute a fundamental change of circumstances which would justify termination of the treaty, especially if a juridical island or a juridical rock no longer exists. However, Article 62, paragraph 2A exempts a boundary treaty from application of this rule. Uncertainty has to a degree existed as to whether this exemption applies only to land boundaries. However, in 1978, the ICJ in the Aegean Sea Continental Shelf case suggested that the VCLT rule also exempted maritime boundaries. The ILC has also endorsed this view in its recent 2020 study. And likewise in 2014, the UNCLOS Annex 7 tribunal in the Bay of Bengal case also emphasised the importance of stability in maritime boundary making and noted the impact of climate change. Thank you, colleagues. I look forward to further discussions on these points.
Thank you, Donald. So I think this really clearly frames the issues in terms of, we now understand what the facts, we understand what the implications of sea level rise are for the law of the sea. Now, I'd like just to focus really now on more the legal framework. And I'd like to turn to you, Cecilia, for that. In particular, what is the legal framework governing rights of internally displaced persons in the context of slow onset adverse effects of climate change, such as sea level rise?
Thank you very much for having me on this panel and for giving me the floor. As you have said, as you have shared, my report to the UN General Assembly in 2020 was concerning the link between the human rights of internally displaced persons as stated, as described by the guiding principles on internal displacement, and the slow onset adverse effects of climate change. Now, this issue of internal displacement in this context, very specific context, which is usually what we're talking about when we talk about sea level rise and other slow onset effects, lies at the intersection of various legal and policy fields, including international human rights law, international environmental law, also international disaster relief law in terms of preparation and response, disaster risk reduction, and sustainable development. And therefore, it's not a matter of looking only at all of these very different international law regimes, but ensuring that there is concerted action among the responses and the basis for enabling the humanity for internally displaced persons. Now, with regard to human rights, which is, I'm going to go very quickly here because of the time, there is really extensive evidence of the widespread impact of climate change on the enjoyment of human rights. We've got the science, the hard science, but we've also got the social science and the, really very, very clearly the effects on the human person. And these human rights are the rights to life, health, housing, food, water, education, even cultural rights and other collective rights, such as the rights of indigenous peoples and the right to self-determination. This is all evidence and actually still ongoing in terms of monitor. Now, you have mentioned a while ago that just very recently, the Human Rights Council has actually recognized, finally, the human right to a safe, clean, and healthy and sustainable environment, which we are all, of course, welcoming. But those impacts contribute what's happening now, the adverse effects to climate change contribute to displacement, and displacement further impacts enjoyment of human rights. So when it comes to human rights, we get our guidance. It's soft law, the 1998 guiding principles on internal development. However, if you will be looking at specific principles under the guiding principles, many of those provisions, many of those principles have actually now crystallized into customary international law, if they do not actually in the very first place already exist under hard treaty law. States have also made commitments under international environmental law on climate change mitigation and adaptation, which are really essential for preventing and addressing displacement. And we know that we've got the COP26 happening very soon, and so there's will be a lot of discussions concerning the United Nations Framework Convention, and that's a convention on climate change as well as the subsequent agreements negotiated under its umbrella, such as the 2010 Cancun Adaptation Framework, etc., etc. I also would like to make explicit reference to the Warsaw International Mechanism for Loss and Damages associated with climate change impacts. This was mandated to establish a task force on displacement related to the adverse impacts of climate change, particularly because of the effects on humans themselves. And on the basis of its work, the Conference of Parties had already welcomed a series of recommendations, including, hopefully, and this will, especially with Elisa being on the ILA, regarding the formulation of laws, policies, and strategies that reflect integrated approaches to climate change-related displacement in the broader context of mobility. I should also mention, the last 2 minutes, the 1994 United Nations Convention to combat desertification in those countries experiencing serious drought and/or desertification, particularly in Africa, and which looks at the relationship between desertification and climate change. Let's also not forget about the other soft law instruments. Now that we've done the hard law, the other soft law instruments such as the New Urban Agenda and the Sendai Framework, etc. But I would also like to add that as far as Africa is concerned, we do have a hard law there at the regional level under the 2009 African Union Convention for the Protection and Assistance of Internally Displaced Persons in Africa, which actually covers internally displaced persons who have been forcibly displaced because of the adverse effects of climate change. There is also the 2006 Protocol on the Protection of and Assistance to Internally Displaced Persons adopted at the International Conference on the Great Lakes region, which is binding on a lot of countries. To cap it all, I would like to, of course, mention that there is a myriad of other national laws and policies specific to national jurisdictions that are also relevant, particularly those on migration, displacement, and relocations, disaster risk reduction, climate change mitigation and adaptation, and of course, those protecting human rights. Thank you very much.
Thank you, Cecilia. I'd just like to ask you just a follow-up question on the convention that you mentioned to combat desertification, and to see whether states have actually sort of taking advantage of this convention so far, and if so, why or why not?
Yes, this is actually a very important convention, and rightly so. I do not believe that there has been much acknowledgement that this is completely relevant to the adverse effects of climate change, particularly slow onset, of course, on the rights of peoples and the rights of peoples not to be internally displaced. This relationship between desertification and climate change recognized by the convention, unfortunately, is not very much acted upon nationally nor internationally. So, of course, I can only exhort governments and international policymakers as well to give more particular attention to this convention, because we've got a lot of frameworks, of course, and some of them are not completely sufficient, obviously, with the very fast scientific developments on the effects of climate change. However, what we have is what we have. And I think it is important to really take advantage of those existing conventions right now, while there is, of course, the encouragement at the international level to formulate other laws and policies. What we are looking at right now is not only with regard to what the law is, but also the implementation of those laws in those particular countries that are affected.
Absolutely. Thank you very much, Cecilia, for this edition. Now, you focused, of course, as the special rapporteur, on internal displacement mostly, and I'd like to sort of turn to the cross-border context. And for that, I'd like to turn to Nicolas. Can you please tell us a little bit about the legal framework governing the rights of displaced persons in that context, in the cross-border context?
Thanks, Florian, and thanks very much for the invitation to be here today. And it's a particular privilege to have Cecilia, the Special Rapporteur, with us and to hear firsthand all of the incredible work that she's been doing in this area in the last few years. Moving away from the internal displacement into the cross-border context, as Cecilia's outlined, the vast majority of people displaced by climate-related threats do remain within the borders of their own countries, and that's a really common misconception when people talk about climate refugees, as it were. But of course, there are also significant groups that are going to be displaced across borders, and the difficulty that those who've been following this debate for years now is that the 1951 Refugee Convention is not suited to addressing the rights of those who are displaced across borders because of climate impact. And the reason there is because the definition in the UN Refugee Convention is based upon someone owing to the well-founded fear of being persecuted for reasons of race, religion, nationality, or membership of a particular social group or political opinion is unable to return to their country. And so there have been there's been a lot of discussion in the international community, the academic community, around what could be done to fill that apparent lacuna in international law, a new international treaty, a protocol to the UN Convention, a specific protocol to the 1992 UNFCCC, an extension of the guiding principles on internally displaced persons, specific regional arrangements. There was in 2018 the UN Global Compact adopted, speaking to migration and refugees more generally, but which specifically focused on the climate impacts on international migration. And I was interested to see that in the last 18 months or so, there has certainly been a specific recognition from the UNHCR as to the applicability of the 1951 Convention in specific circumstances, and then I think a practical approach of moving beyond legal form and actually just trying to address the problems and work out what needs to be done to sort out potential responses to international migration. So the UNHCR has appointed a special advisor on climate action. That was just at the beginning of 2020. And the UNHCR has recognised that the 51 Convention could be specifically applicable because of the interaction between the effects of climate change and the impacts, particularly on marginalised groups. And so obviously groups fleeing climate change impacts are likely to be at increasing risk of persecution because of the linked economic effects of climate change or conflict over natural resources. There's likely to be a real connection between conflict risk of persecution and those longer term impacts of climate change. Interestingly, the UNHCR also focused particularly on environmental and climate rights defenders who are at risk of persecution as being a group that's often overlooked in this context. And so there's been a real recognition of that, which I was really interested to see has been picked up, particularly in the US, just in the last couple of weeks, which I'll go on to speak about. So in terms of the UNHCR's practical approach, the UNHCR really expressly recognises that the intersection of climate change and disaster means that there's going to be this real risk of violence, conflict and persecution leading to displacement. And as a refugee protection agency, they are looking at climate change as a risk or a threat multiplier for other drivers of displacement. And that can be seen in Cecilia's work as well. And one thing just to close off, briefly this introductory remark is that just in the last couple of weeks, there has been the release in the US of the White House report on the impact of climate change on migration. Now, that was something that President Biden requested when he came into office, and it is a very detailed report that really is hot off the press. And several of the recommendations of that caught my eye. One is that they have recommended that the US should consider how to contribute to climate-related displacement, including via the multilateral institutions and particularly the MDBs, the development banks. They've recommended bold cross-cutting multilateral leadership, which I thought was an interesting and really exciting position to be recommended. And they've really picked up on this intersection between climate change and claims for refugee status. And the grounds that they're specifying are those same grounds that the UNHCR Special Advisor has recognised within the last couple of years. So you can see that being pulled across into this work in the US. So it's the environmental defenders where there's no relocation alternative, or where individuals being denied relief from climate change impacts because of other socioeconomic drivers. So you can see that there is progress happening, and you can see the way that these suggestions are being picked up, for example, in the US, and so that was pleasing to see. But it is still one of those difficult areas of international law where I think there's a lot of focus on progressing hard law solutions that doesn't necessarily actually help the people who need the help in the short term, and you can see that approach being recognised by the UNHCR at that level.
Thank you, Nicola. I certainly highly recommend as well reviewing this very interesting report, hot up the press, as Nicola said, and very timely, of course, with COP starting just this Sunday. But for sure, a very good report. Now, so we've talked about displacement, both internal and cross-border. I'd like to just spend a few minutes with you, Donald, to talk about really the special scenario of small island states. We saw that recently Vanuatu, declared that it wanted to seek an advisory opinion from the ICJ. Could you please address for us sort of some of the special considerations, including statehood, that arise in this regard?
Certainly. So the first issue that arises is whether an island becomes so awash such that it is no longer above water at high tide and becomes what law of the sea lawyers call a low tide elevation. Now, such an event would not be extraordinary, and there are examples of where naturally formed islands do, because of erosion, become inundated with water at high tide and effectively become low tide elevations. This is especially the case with small, recently formed volcanic islands, which due to their instability are prone to erosion by the sea. Low-lying islands may therefore, because of sea level rise, see their status converted from being an Article 121 island to an Article 13 low tide elevation, with consequential impacts upon the maritime entitlements of that feature. However, the much more significant consequence is where a juridical island becomes a juridical rock because the feature is no longer capable of sustaining human habitation or an economic life of its own. This could arise from the loss of potable water, the loss of agricultural land, seawater soil contamination, or the diminution of habitable land. The temporal dynamics associated with the loss of these characteristics would also need to be taken into account. Outward migration from the island and abandonment of any form of settlement and associated activity may be an indicia of the island's changed status. Technological mitigation strategies, and especially the potential to undertake land reclamation in response to sea level rise and inundation, would also need to be taken into account. And as the 2016 South China Sea Tribunal noted, it actually diminished the significance of size in distinguishing between a juridical island and a juridical rock. And therefore, size in itself would not be a decisive factor in determining the island's juridical status and whether that was altered. Now, given the precedent that has been set by land reclamation and artificial island building activities in the South China Sea, it must be anticipated that some states will engage in these activities in response to sea level rise. Singapore, for example, has put in the public domain its intention to engage in, and I quote, engineered solutions such as building seawalls and dikes, complemented by nature-based solutions such as active mangrove restoration. And it's being suggested that something up to 100 billion Singaporean dollars might be spent over the next 50 to 100 years in those types of mitigation strategies. The building of artificial islands in response to sea level rise is also an option for coastal states who are fearful of losing habitable land, and especially in the case of small island states. And an example of that response is in the case of the Maldives, where an artificial island has already been constructed next to the capital, Mali, at 2.1 meters above sea level to allow for future sea level rise. Now, as to the precise issues you asked me to address about statehood, international law has long accommodated the growth and loss of territory which may arise under a variety of circumstances, including from natural events. While international law assumes the continuity of states, statehood may, of course, be extinguished under a number of circumstances, and a state may no longer exist and enjoy sovereignty over territory. While territorial loss for an existing state is not exceptional, territorial loss from projections associated with sea level rise would be exceptional and have a very particular impact upon island states. This could extend from the complete loss of all state territory or impact upon territory, making it, as I've described before, uninhabitable, to the loss of specific islands or parts of islands. Traditional international law, as we know, places a heavy emphasis upon territory being an essential state attribute as per the Montevideo Convention criteria. However, this requirement can be met by very small areas of land, as in the case of the Holy See or the Vatican, which has 0.44 square kilometres of land. Therefore, that a state is diminished due to sea level rise does not impair one of the essential attributes of the state. The state can still continue to exist and be recognised as such, albeit, of course, with reduced territorial entitlements. The most significant issues that arise in the case of where territory of a state becomes uninhabitable as a result of sea level rise and the inhabitants having to abandon the territory, or exceptionally where the territory completely disappears. Ultimately, this raises the prospect of whether international law absolutely demands the existence of territory for a state, or whether it may be possible for a deterritorialized state to exist. And this is one of the issues that the International Law Association Committee is looking at the moment. So the impact of sea level rise upon island states and the real prospect of deterritorialization to the point that the territory of the state disappears may allow for serious reconsideration as to the centrality of territory to continuing statehood. Now, there are some interesting historical examples in this regard, and one that I'm mindful of is the Order of Malta, which possessed territory over islands in the case of Rhodes and then Malta up to 1798. Control over those territories were lost, yet the order, as we know, still functions and is recognised as possessing international legal personality, though not at the level of a state. In the digital age, this could even extend to data or virtual territories. In the case of islands, this particularly highlights whether a state facing the prospect of deterritorialization could seek to build artificial islands within its existing territorial sea, to which the population could relocate if the natural islands become uninhabitable. State practice from the Maldives that I've referenced indicates that some island states are pursuing that option, and this may in turn raise future issues as to the status of such artificial islands if much of the existing land in the Maldives, for example, is lost to sea level rise.
Thank you, Donald. So we've identified the issues, we've identified the legal framework. Now, I'd like to really address how we actually propose to address those issues. What is the international community? What are the states doing to sort of address the consequences of climate change in this particular regard? And to discuss this, I'd like to turn back to you, Elisa, for a moment, and really sort of building on your experience with the ILA, but also, more broadly addressing how international bodies such as the ILA, the ILC, the IBA, and I would of course welcome remarks as well from Nicola based on her experience with the IBA. How are those international bodies influencing the debate?
Yeah, thank you. I'm very happy to give some insight about the work we are doing, and because I think first of all it's important to highlight that I think international law scholar, as already Nicola said, I think they are making significant progress also to try to understand whether and how existing regimes may offer some degree of protection for those who move or are at risk of having to move internally or cross-border. So I think it's quite interesting to see, in particular, the work that now has been conducted by, I will focus mainly on the ELA Committee on International Law and Sea Level Rise, and also I will say a few words about the work that has been done until now by the ELC Working Group on Sea Level Rise and International Law. So I will start with the ELA Committee, because I think it's very important to remind that the ELA started to really focus on this issue in 2012, and it has been created with a two-part mandate. So the first one was really to study the possible impact of sea level rise and also the implication under international law of the partial or complete inundation of state territory, with a specific focus on small island and low-lying states. But also the second part of the mandate is really to develop a proposal to also encourage the development of international law in these specific issue areas. And for doing this, there are three key issues area that the committee is really focusing on: is the law of the sea, forced migration and human rights, and also statehood and international security. And the work of the committee has been divided in two parts, also regarding the timeline. So the first phase has been concluded in 2018. And in this phase, the ELA committee adopted what they identify as a short-term perspective. So to deal with the focus that can be addressed in a short-term perspective. So the focus was clearly law of the sea, and together with the migration and human rights issue. And for me, it's super important to highlight that as a result, as an outcome of this first phase, has been the adoption of the Sydney Declaration on the protection of a person displaced in the context of sea level rise. And this instrument has been adopted in 2018, which really the overall aim was to offer guidance to states in averting, mitigating, and addressing displacement occurring in the context specifically of sea level rise. And this declaration contains 9 principles that can be looked at with a specific commentary. Is a very well articulated document. Now we started the second phase of the ELA mandate, and I'm joining this part of the work. So now what we are doing, we are really trying to address the mid and long term impact of sea level rise. And again, we frame our debate around the law of the sea, statehood, and the protection of affected population. And again, I'm working mainly on this last issue, so the protection of affected population. And what we try was really to map a little bit the existing frameworks at different levels. So we conducted a preliminary mapping exercise, and this has been done at international, regional, and national level. And the idea was really to combine our effort with other initiatives. So I will include also the Nansen initiative. So because the Nansen initiative adopted in 2015 the protection agenda. And this instrument was the first that tried really to map the legal frameworks available, together with the work that, as Cecilia mentioned before, has been done by the UNFCCC Task Force on Disaster Displacement, because they also conducted a mapping exercise. So we are really trying to complement all these initiatives because I think now we can really start to see a lot of state practices that are really join the pictures. But again, I think the preliminary result identify that it's true. We see that there are increasing effort at international level, but at the same time, if we look at the state practices, we can see that there are mainly the most affected countries, as for instance in the Pacific, that are advancing this effort at domestic level, because we had a significant instrument adopted, for instance, in Vanuatu or in Fiji related to planned relocation, but there we see, because I think the impact are concrete, but it's less advanced in other at the other level, I would say. And I will conclude really very short by focusing on the work of the ESC, because I think also it's very important is the ESC has included in the long term, in its long term, also this topic in 2019, and they decided to create an open-ended study group on sea level rise in relation to international law. And again, also the study group identified 3 subtopics that you can see are quite close of the subtopic identified by the ELA committee. So again, in relation to the law of the sea, statehood, and the protection of persons affected by sea level rise. For each subtopics, the study group agreed to prepare an issues paper, and this is the basis of the debate. And the first issues paper has been released into 2020, and this has been discussed, I think, during the last session, last summer 2021. So, and the focus was on the law of the sea. About the other issues, statehood and the protection of person, the report are the issues paper are expected for next year, because it's true that COVID had an impact also on the schedule of the work of the ESC. But anyhow, just to focus on the topics, what the overall aim of the ESC study group is, again, to try to identify the principle that in international law can guide the protection of people affected by sea level rise. And about the methodological approach, what is extremely relevant in the case of the ESC is that the study group aims to revise the existing international law, so treaty and customary international law, but also state practices. And it's clear that the ESC has an access that is really privileged to get also information that maybe are less accessible, for instance, to the members of the ELA committee. So to conclude, I would like to also say that it's very important for us to complement each other, and I think it's working very well, because also some members of the ELA are also members of the ESC working group, and it's a very, very fruitful cooperation, I think, at international level. So thank you.
Thank you, Elisa, and thank you for your contributions to the ILA. I just want to take just a minute to turning to you, Nicola, as well, very quickly, to sort of hear a little bit of the work done by the IBA.
Thanks, Florian. The IBA, I was really proud to be involved with the work of the IBA. This was back in 2013, 2014, and the IBA put a lot of work into its report on climate change justice. And that was really at the time that climate change and human rights were not automatically connected in the way that they are recognized now. And it's really exciting to see actually the progress in that area, and a huge amount of credit there needs to go to Professor John Knox, who was the special rapporteur at the time, really driving that change. But the IBA task force pulled together deliberately environmental academics and human rights academics and climate change experts, and sort of forced them to work together and speak to each other and try and look at how international law could respond to the challenge of climate change from a climate change justice centric approach. And that was a pretty exciting project for the IBA to embark on, and really pushed the IBA and pushed the boundaries of sort of where it might have traditionally focused. And that report then led to the formation of several working groups in different areas, one particularly on climate change adaptation. And that working group has spent some time working on how it could progress some of the really specific recommendations that came out of the IBA task force report. That work was being led out of Ireland by Conor Linehan, who is based in Dublin. And I haven't been in touch with Conor in the last 18 months because of COVID, if not many other things. So I'd be really interested to see where that working group is particularly. But certainly you can see, as Elisa says, the resources that you have through these organisations like ILA, ILC, and the access you get to people across the world, IBA, it is a real opportunity to push things forward. And I think there's certainly just much more that can be done to continue that work. So it's really great to hear of the specific work focus that Elisa is focused on.
Absolutely, absolutely. Thank you, Nicola. I'd like to actually stay with you for the next few minutes to really talk about adjudication now. What are the legal fora in which climate change related issues, especially as they relate to migration, can be adjudicated? If you could maybe talk, and of course, there's this famous case involving New Zealand, which I'm sure will be part of the focus of the discussion, but I think it would be very helpful for the audience to hear, where are those issues adjudicated?
Thanks, Florian. So it's interesting, Australia and New Zealand and the Pacific are popping up perhaps expectedly in a lot of these early decisions in adjudicative fora around claims for refugee status because of rising sea levels or impacts on particularly the Pacific states. And back in 2009 was one of the early cases before the Australian Refugee Tribunal, which was an individual from Kiribati who was seeking to fall within the refugee categories under Australian law because of impacts of climate change and was refused. A similar issue came up in 2014 in the New Zealand Immigration Tribunal. That was a Tuvalu citizen who was seeking refugee status, applying under humanitarian grounds. Again, that was rejected. In 2015, Mr. Tietiota, who is the individual who has subsequently gone to the Human Rights Committee, he came through the New Zealand courts and went through to the New Zealand Supreme Court, or sought leave to take his claim to the New Zealand Supreme Court in 2015. It already feels like a wee while ago now. And the Supreme Court refused to accept his application for refugee status on humanitarian grounds under New Zealand law. However, didn't completely leave the door closed to climate change impacts, opening a pathway into these types of decisions, drawing on the Refugee Convention, but wasn't going to allow it at that stage. And that led to Mr. Tietiota being reaching the end of his domestic remedies that he could have gone through in New Zealand, and he took his case to the Human Rights Committee. And the decision there has been very significant. So this was a decision last year from the Human Rights Committee. Mr. Tietiota took his claim under the asserting a breach of the ICCPR, specifically a breach of Article 6 and the right to life. And it was a really interesting, it's a very interesting decision to read the views of the committee. And they look at the likely physical impacts of climate change on Kiribati, and there was expert evidence as to the impact of sea level rise on living conditions and impact on the right to life in Kiribati. And for Mr. Teotiota, the claim didn't succeed. The committee wasn't willing to grant him the relief that he sought, but they did make some very significant statements recognising that climate change may expose individuals to breaches of rights under the ICCPR, particularly Article 6, and also the right to dignity, such that those breaches would trigger states' non-refoulement obligations under international law. And they particularly looked at whether or not Mr. Teotiota would have his rights impacted by living in Kiribati, and they said that in the next 10 to 15 years, those impacts were not sufficiently imminent to trigger the obligation under international law. But they said that, and they specifically recognised that there was still time for intervening acts by the international community and by Kiribati itself to change the position so that Mr. Teotiota's rights wouldn't be sufficiently impacted to trigger the non-refoulement obligation and the breaches of the ICCPR. And that decision it's been welcomed for the fact that it's been such a clear recognition that climate change could put a state in breach such that it could trigger those non-refoulement obligations. It's also been criticised for not recognising the science and the forecasts around impact of sea level rise in the Pacific. And I think that even if this decision had come out after some of the more recent scientific reports we've had from the the International Panel on Climate Change, the IPCC, you could have had actually a quite significantly different decision, which could have found that there was a sufficient risk of imminent harm. But be that as it may, it's a very significant decision, and I certainly expect that other claims, particularly from Pacific states, will be brought in the trail of that decision and using the latest science to argue that indeed we are now in the position of being able to see a serious risk of imminent harm, such that would trigger states' non-refoulement obligations, and that will really cause difficulty for state courts that have been having to interpret and apply international law in the domestic context. Another interesting development earlier this year in France that I thought was worth mentioning, there was a decision where a Bangladeshi man was apparently the first to avoid deportation from France because of the court recognising environmental circumstances in his home country. So this wasn't climate change per se, it was dangerous levels of pollution and his particular health concerns. He had severe asthma, and it was the Bordeaux Court of Appeal that held that risk of serious deterioration to his health in his homeland was sufficient to refuse the deportation order in France. So again, you can see claimants picking up that and pairing it with what's happened at the Human Rights Committee and building further cases based on that decision. Two cases connected to Australia that I wanted to touch on. One is the claim that the Torres Strait Islanders have brought to the Human Rights Committee. That's been fairly well known. They brought this in 2019, this claim to the Human Rights Committee, again seeking asserting a breach of the ICCPR on the basis that the Australian government had failed to protect their rights to life because of the Australian government's failure to take sufficient action on climate change. In December last year, the UN Special Rapporteur on Human Rights and the Environment, Professor David Boyd, together with his predecessor, Professor John Knox, who I mentioned before, actually filed an amicus brief in support of the Torres Strait Islanders before the Human Rights Committee. And there they significantly said that by failing to accept that climate change is affecting the Torres Strait Island people, and failing to substantially reduce emissions, and failing to facilitate adaptation to the changes, the Australian government is not meeting their human rights obligations. So it's a very strong statement from the Special Rapporteur and Professor Knox. Just in the last week, the Torres Strait Islanders, two individuals, two leaders from the Torres Strait Islands have filed a new claim, this time in the courts of Australia, and they've filed a class action against the Australian government in the Federal Court of Australia, asserting that the federal government has breached its duty of care towards the Torres Strait Islanders by failing to do enough on climate change. And there's a real increasing pressure on the Australian government, which really has not been at the front of climate change efforts, and a real call from Australian civil society, Australian international lawyers, for the Australian government to be doing more. And this new Australian-based claim will certainly up the pressure on that. Two final points. One is that you mentioned earlier, Florian, the ICJ campaign that Vanuatu has launched recently. That is a really interesting development, something that people have been in this community will know has been talked about for a long time, and no one has yet actually pulled the pin on it to try and get it off the ground. And the Vanuatu government has now launched a campaign to take this through the UN General Assembly to the ICJ, wanting the ICJ to clarify the responsibilities of states for climate change under international law. And I was attending a really interesting webinar a few weeks ago that Professor Philippe Sands was speaking on, and he was referencing this case and had some very wise comments around being very careful as to how the question is framed. He referenced the nuclear weapons advisory opinion as a really good example of how this can be a really high stakes and dangerous in a way step to take an issue of this significance to the ICJ. And so I'd be really interested in all of your views and participants' views as well. There'll be a lot of very experienced people in this audience with views as to how best to frame that before the ICJ. Certainly the Vanuatu students who have been pushing this and have taken it through the Vanuatu government, I know will be looking for input as to how best to do that, to take that forward. And then the final point I just wanted to make was that outside of all of the adjudicative fora, obviously there's a real political response to these issues. And something that got a lot of media attention a few years ago was the New Zealand government announcing an experimental humanitarian visa category for Pacific Islanders displaced by the impacts of climate change. And there was a hasty about-face about 6 months later where the New Zealand government sort of retracted from that announcement. And interestingly, it wasn't because they were suddenly worried about the large numbers of people that would be applying for that visa. It was actually because of the reaction from the Pacific Island community in New Zealand and in terms of international relations with the New Zealand government, which was that should be very much a last resort. They wanted emissions reduction, adaptation funding, and legal migration pathways. And that's something that I've really noticed from a Pacific perspective, is that there's been a real demonstration of strength and capacity and coordination in the Pacific dialogue around climate migration. And in some of the most recent work that's been happening that I know Cecilia's been involved in the last year or two in the Pacific, there's been a real call for safe labour migration as a climate change adaptation strategy. And I think that's really important not to lose focus on. So labour mobility schemes, bilateral arrangements, permanent resident schemes with the sort of humanitarian or emergency visas only as that very, very last resort, which aligns with respect for dignity, etc., under the ICCPR as well. So that is something that the Pacific legal community has really deliberately taken a firm stand on, and some of the work coming out of those consultations is very impressive.
Thank you, Nicola. I'm sure we will all be watching further developments before the Human Rights Committee, before the ICJ or other international tribunals. And certainly the framing of the legal question is really the crux of it for requesting an ICJ advisory opinion. So thank you for flagging this issue. I'd like to finally turn back to you, Cecilia, really to sort of end on a note that relates to policy considerations. And in particular, what I would like to hear from you is, what are the important policy battlegrounds going forward? What do you anticipate the international community can do to address those issues?
Thank you so much, Florian. And let me just do a little segue from Nicola's very articulate rendition. And this is with regard to one specific case that is actually also groundbreaking. And this was a decision of the Child Rights Committee under the UN Convention on the Rights of the Child, where it provided just this October 10, October 11, a first ruling by an international body that actually countries bear cross-border responsibility for the harmful impact of climate change on children. So this is a case that was came out coming out from a petition filed by 16 children from 12 countries against Argentina, Brazil, France, Germany, and Turkey in 2019. And the children claimed that these 5 countries, which were historic emitters, had recognized the competence of the committee to receive petitions, however, had failed to take necessary preventive measures to protect and fulfill children's rights to life, health, and culture. So going back to your question just now, where are the policy battlegrounds? And I would like to put an emphasis on one particular policy battleground that is very relevant and actually very urgent. And coming from this case I just provided, the children actually in this case argued that the climate crisis is not an abstract future threat, and that the 1.1 centigrade increase in global average temperature since pre-industrial times has already caused devastating heat waves, fostering the spread of infectious diseases, forest fires, desertification, extreme water patterns, floods, sea level rise. And as children, they claimed they were among the most affected by these life-threatening impacts, both mentally and physically. And although the Child Rights Committee did not actually dismiss the case, the concrete case, because of the lack of domestic exhaustion, but the Child Rights Committee nevertheless gave this ruling about the cross-border responsibility of countries. So this is very relevant to potentially displaced persons internally and cross-border. Now, the reason I am giving this as an example is because the battleground is with regard to the importance, the urgency of enabling the merger, the integration of the human rights of affected people and the science that we have already right now. And these are two pillars of knowledge, expertise, and experience that should be put together, integrated, when we talk about the policy and legal battlegrounds in law. This is, of course, you know, Nicola has just provided us about this case in New Zealand, where the science was not taken into complete consideration. This is going to be really the important battleground. I was speaking to a person in OCHA, sorry, not OCHA, to the UN DRR just a few months ago. And what she was telling me is that it's really time to ensure that both legal aspects and policy aspects come together very concretely with the view and the vision of concretely protecting the human rights of affected population. That, for me, is the battleground that we have right now. And it's going to be a long haul. So we may be doing a lot of things legally, but it is important to take the aspect of protection of the people themselves and prevention, mitigate the potential losses because of climate change effects, both sudden and slow onset. Thank you.
Thank you, Cecilia. I think you really summarized it well. I think it's a very positive note to end on, an inspiring note, the importance of protection and mitigation. I see that we are just at 5 p.m. And I'm not seeing any questions from the audience. So I suggest that we break. I want to thank you, really all the wonderful speakers for their contributions. I thought it was extremely lively and insightful discussion, and I hope that you all enjoyed it, and I look forward to seeing you next year, hopefully in person, all the speakers and also the participants. So thank you again. It was really a wonderful panel. With that, take care. Bye-bye.